Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. I want to encourage you today. I want to talk about being proactive. And being proactive starts before the lawsuit is filed. So let's look at some ways in which a pro se litigant can be proactive. And also, let's hear some pro se litigants' comments on being proactive. So let's get started. Plaintiff should know the facts before the lawsuit is filed. Know your facts well. Remember to write short and plain statements of the facts that show the plaintiff is entitled to relief. Write each fact specifically, creating plausibility. The facts are critical. Federal Rules Civil Procedure 8A2. The plaintiff always wants to know the law that he or she is relying on supporting their lawsuit. Before the lawsuit is filed, research and locate statutes and read case law that supports each of the claims. Identify the prima facie elements for each claim. What are you doing here? You're warding off a 12B motion to dismiss. Now, can you imagine a child going to his father and saying, "Dad, I got straight A's this semester. So now will you purchase that bike you promised me if I got straight A's?" Well, Dad wants to see what? Evidence. The evidence is his report card. Either son is going to present the report card or he isn't. And the report card either shows straight A's or it doesn't. In a lawsuit, it is critical that plaintiff conduct discovery. It is how plaintiff obtains the evidence needed to support their allegations. Now, at this point, since discovery is moving forward, one could presume that at the end of the discovery period, defendant is likely to file a motion for summary judgment. Federal Rules Civil Procedure 56. So Federal Rules Civil Procedure 56 requires that the plaintiff produce evidence to prove its claim. And the plaintiff must cite the evidence and identify the evidence in the record where the court can go right to that evidence. It is likely that the defendant will file a motion to dismiss, and the plaintiff could face other motions, assuming that the plaintiff would succeed in a motion to dismiss. Here's my point. Be prepared to be served with a motion, at least one, and may be multiple motions during the course of the litigation. Don't be intimidated. Respond. Now I want to get into comments. Comments that pro se litigants made on my YouTube channel. And I wanted you to hear these just to be encouraged. Be encouraged to be proactive. Get courage. You can do this. It's doable. So let's hear what these pro se litigants had to say. J.E. said due diligence is as important as discovery and the material evidence. Do your due diligence. said yes, facts, the law, and plausibility are of supreme importance. To my fellow pro se plaintiffs, stay on course. Expect a protracted fight. True. ESS said the judge dismissed my complaint and I filed a judicial complaint on him for misconduct. Filed a motion for reconsideration and was finally granted relief. Thank Jehovah God. ESS said every pro se litigant should learn the rules of the court. Critical. DD said, I just use all these steps, referring to steps that I referenced in the video, including FOIA and lack of jurisdiction, and the judge and attorney left. I'm finally, after 12 years, moving the case to trial because he or she was proactive. Emmy said, great resource. I will be using it for the remainder of my pro se case. AT said, I have been working relentlessly to learn laws and procedures, but still was struggling with how to implement them. This is exactly what I needed. AT is ready to go. DD said, it is the night before the Rule 12 hearing regarding a civil matter against my home insurance company, which I am a pro se plaintiff litigant. And I feel so much more prepared now for after viewing your video. My approach is to do exactly what you suggest regarding mirroring the defense's motion, but I will present my response in my oral argument. CJ says, the railway. 1 year ago, I love it. I filed my case pro se. Thank you. Awesome, CJ. Hey guys, be informed, be proactive, be empowered.